Good morning. Today at Google, we are delighted to welcome Mr. Timothy Edgar. Mr. Edgar is a former national security and intelligence official, cybersecurity expert, privacy lawyer, and civil liberties activist. He joined the American Civil Liberties Union just before 9/11 and spent 5 years fighting in Congress against abuses in the war on terror. He then left the ACLU to try to make a difference by going inside America's growing surveillance state and went on to advise the George W. Bush and Obama administrations on privacy issues and cybersecurity. In 2013, he left government for Brown University to help launch its professional cybersecurity degree program, and he is now a senior fellow at Brown's Watson Institute of International and Public Affairs. He's here today to discuss his new book titled Beyond Snowden: Privacy, Mass Surveillance, and the Struggle to Reform the NSA. Please join me in welcoming Mr. Timothy Edgar to Google.
Well, thank you very much, David, and thank you to Google for having me for this talk on privacy, mass surveillance, and the struggle to reform the NSA. And I'll be talking about my new book, Beyond Snowden. And first, I want to start out with thoughts about making a difference and what it takes to make a difference in our age of mass surveillance. Now, I had a theory that I could make a difference by working within the surveillance state, and I tried to do that for a period of about 2005, 2006, up to 2013. And there was another person inside the surveillance state at that time who I actually never met, and he had a different idea about how to make a difference. His name was Edward Snowden. And instead of working within the surveillance state to try to reform it from the inside the way I did, he decided to make this extraordinary decision to steal troves of classified documents, go off to China and then Russia, and kind of blow up the whole system. So I want to talk a little bit about which tactic worked better, which was more effective, and then think about what we can do going forward as the book is entitled Beyond Snowden. So to not hide the ball, I'm going to give you my conclusion up front. The results that I had working within the system were results that I'm proud of. We made some significant achievements. We took some Bush-era, post-9/11 domestic surveillance programs, or at least programs that surveilled domestic data. We put them under the framework of the secret Foreign Intelligence Surveillance Court, briefed Congress on them. We brought them within basically the framework of our Foreign Intelligence Surveillance Act. We also made some important improvements in oversight of those programs. I worked personally on those improvements to create what I call a middle way between purely domestic surveillance, where you have individual court orders of wiretaps, and the kind of foreign surveillance the NSA does with far less oversight. We did something kind of in the middle. The Prism and upstream collection programs you may have heard of, and we designed the oversight system for that. But I have to admit, we really miss the broader impact of all of these mass surveillance programs on the privacy not only of the United States, but of the whole world. And the reason that we missed that broader impact is that we were working within a very outdated legal framework, a framework that really is from the analog age of the 1970s, and which the main goal of which is to prevent abusive domestic spying for political purposes. It's not to safeguard privacy in a global age of mass surveillance. So what were the results that Edward Snowden had in 2013 with his massive revelations of NSA spying? Well, 4 years later, we can render somewhat of a verdict on the results of the Snowden revelations. First, there was an absolute revolution in transparency. And we'll talk in more detail in just a few moments about that. But this isn't just Snowden's own leaks of information. Obviously, that made those programs that he leaked transparent. But the government fought back with more transparency, which was a bit of a surprise. Now, they did this in a tactical way to try to defend themselves against accusations these programs were out of control and didn't have any privacy safeguards. But I would argue that this has created a lasting change in the culture of secrecy of the intelligence community, although a fragile one. and there's a real danger of going back to bad habits. A real revolution there. An end to a domestic bulk collection program. In 2015, Congress basically took this program that I'd worked on for many years that was kept secret from the American people and decided to end it. It had not proved as effective as we had thought, and there was a better way to collect telephone records. That was a major reform to the Patriot Act. And reforms to the Secret Foreign Intelligence Surveillance Court that resulted from the reaction to Snowden, including appointing outside lawyers to argue the other side in cases that affected privacy. But I think that the most important change that resulted from Snowden's decision to leak classified information in 2013 was a change to our entire conception of privacy that the government and the intelligence community use. For decades, privacy meant Americans. When I was in government, when I told people that I worked on privacy and civil liberties issues, the first thing that came to their mind was, well, how much data about Americans do we have in this program? If it's, a fair amount, then we'll let Tim look at it. If this is mainly a foreign program, this really isn't something for the Privacy Office. Now we have rules to protect the privacy of foreigners. Now these rules, I don't want to oversell them. They're relatively modest. But the fact that there are rules at all in a policy directive that President Obama issued roughly in 2014, implemented a year later, is really a revolution for the intelligence community. So what's the verdict here? Well, I think the verdict is obvious. Snowden's way was much more damaging, but it was also much more effective than my way of working inside the system. So the question I want to ask, and I talk about in the book, is, what are we going to do with that information? Can we do better than that? Are we just going to wait around for another 10 years and hope that another Snowden emerges to tell us about mass surveillance programs in the future? Or is there a way to reform the system so that people like me on the inside have a fighting chance to ensure effective protections of privacy without the need for a set of massive leaks? Now I'm going to go back in time a little bit to talk a little bit about the birth of the mass surveillance state. And that's going to bring us back to September 11th, 2001. A few weeks after that terrible attack, I was an ACLU lawyer in Washington, and we were gathered on the steps of the Capitol trying to persuade lawmakers as they walked over to vote for the Patriot Act, the new anti-terrorism surveillance law, that they really ought to stop and think about what they were doing. That the powers that they were voting to give the government had not been fully thought through, and that we needed to take some time to figure out how to better protect our country while still preserving privacy and civil liberties. We didn't get much of a hearing. The law passed overwhelmingly. Both parties voted overwhelmingly for it. And back in the office, our director, Laura Murphy, who you can see here in this slide, was asking the question, are we becoming a surveillance society? And it was a real question that we frankly didn't know the answer to, because we didn't know how the government was planning to use its new powers. So we got together with other groups to try to imagine hypothetical scenarios that would illustrate the dangers of these new spying powers. One of the examples we used was based on a real historical example when the FBI had used earlier surveillance powers to go and try to get people's library records, to uncover people that might be susceptible to becoming radicalized and spying for the Soviet Union. So we worked with librarians to call attention to the fact that under the Patriot Act there were these broad powers to get records, any kinds of records, in order to prevent terrorism. Now, the government at the time kind of ridiculed these fears. Bush's Attorney General John Ashcroft said that we were trying to scare people with phantoms of lost liberty. Phantoms of lost liberty. And I remember that thinking a little bit, actually, the Attorney General has a point. We don't know how these surveillance powers are being used. And so we were, in a sense, fighting phantoms. In 2005 and 2006, I had an opportunity to go inside the surveillance state. The the intelligence community was being reorganized in order to better share information. And a lot of the reason it was being reorganized was to better share information that was domestic with information that was foreign about terrorist organizations. And so there are civil liberties concerns, privacy concerns with doing that. When they created the new director of national intelligence to be the head of the intelligence community, we had a victory at the ACLU and other groups because we created in that office a privacy official that would report directly to the head of the intelligence community. And much to my surprise, they looked to me and said, Tim, would you like to come work for us and be the second employee of this privacy office, the first deputy for civil liberties in the history of the intelligence community? And I thought long and hard about this. This is 2006. My first interview for the job, by the way, at the headquarters of the old CIA building in Washington was the same day that the New York Times broke a story about Bush bypassing the Foreign Intelligence Surveillance Act and authorizing warrantless wiretapping. So this gave me a little pause as to going into the Bush administration. But I decided I really just couldn't resist the chance to find out about all these phantoms that we have been fighting and see if I could make a difference on the inside. What did I learn? Well, I learned that there had been a transformation in our intelligence apparatus. And it wasn't just about international terrorism or Al-Qaeda or 9/11. It was also about the internet and the transformation of technology over the past couple of decades. The map that you see up there shows what the NSA at the time was calling its Homefield Advantage. Look at all that data flowing right through the United States of America. And yet, our laws basically provided court review and protections for this data based on the theory that this was potentially domestic surveillance, even if the data belonged to foreign people. But it turns out there were some loopholes and weaknesses in the way those laws worked. And that's because of the way the Supreme Court had interpreted the Fourth Amendment. Foreign people outside the United States, the Supreme Court had said, they don't have rights under the Fourth Amendment to the Constitution. And also, data that isn't the content of communication, even if you're an American, if the data is not the content of a communication, if it's only the metadata, that also doesn't have Fourth Amendment protection. So using creative lawyering, the Bush administration helped to create an innovative series of mass surveillance programs that took advantage of this Homefield Advantage. Bulk collection of metadata, that means collecting all of it, analyzing it for patterns that would hopefully uncover terrorist groups, and then going after the content of communications where the target, the direct target, is someone who's a foreign person outside the United States, but they might be incidentally, as we say, talking to Americans. So that was the Homefield Advantage of the NSA. Our job really was to take these programs that started very quickly after 9/11 in enormous secrecy, bypassing altogether the Foreign Intelligence Surveillance Court that's supposed to review this kind of data gathering, and putting that under checks and balances. But we did it almost entirely in secret. Now, there was that leak that I told you about of the Bush warrantless wiretapping program, but major parts of the program remained secret while we were in the process of institutionalizing it under all three branches of government. Along comes Obama in 2008. We all remember that hopeful period in American history. And one of the things he did during his campaign was to promise a review of all NSA surveillance programs. It's part of a broader reset of the whole war on terror. Said, of course we need to fight terrorism, but we shouldn't sacrifice our rights and liberties to do so. And his rhetoric was inspiring to many. However, some people might have noticed that in the summer of 2008, he had voted to approve a broad NSA surveillance law. Now, he did it very thoughtfully, as we expect from the former constitutional law professor, with a long post to his supporters who were disappointed, explaining why he did that. And a lot of it had to do with his main concern being checks and balances, saying that President Bush had, put too much power on the president He thought Congress should authorize these programs, courts should look at them, and that's why he was voting for this law. Now, at this time, major parts of the program, as I mentioned, were still secret. We knew about monitoring international telephone calls. That's what Obama had voted for in 2008. We didn't know, and when I say we, I actually don't mean we, I mean you. You didn't know about bulk collection of metadata. I had learned about it a few years earlier. Now, when Obama comes into office, I get a wonderful opportunity to go to the White House to serve as the first privacy official in the National Security Council. And I was hopeful that we would be able to make broader changes than we had made under President Bush. That we'd be able to say, okay, we've put these programs under the court, we've briefed them to Congress, now let's have a conversation about privacy. That never really happened. Obama was briefed on the program, said, well, if the court's okay with them, I'm okay with them. Fast forward to 2013. I'm beginning to wrap up my government service, looking at working for Brown. Meanwhile, Mr. Snowden is thinking about doing something much more dramatic in leaving the government. And along comes my former boss, Jim Clapper, the Director of National Intelligence, in an open hearing in the Senate, and he's asked a question by Senator Wydens. He says, does the NSA collect records on millions or hundreds of millions of Americans? Now, this is a very loaded question, and it's a question that Senator Wydens already knows the answer to. He's been briefed on the programs. So has everyone else on the Intelligence Committee. And in fact, that was part of the checks and balances that we had worked on. But Wydens is upset. He can't get anyone's attention, which makes sense. It's a secret program. So he decides to grill the Director of National Intelligence in public, asking him a tough question. Now, of course, this puts General Clapper in a rather difficult position. He could answer the question honestly and say, well, Senator, as you know, the answer is yes. That would reveal the existence of the program. He could also say, I can neither confirm nor deny whether or not the NSA collects hundreds of millions of records of Americans. That would also kind of imply that the answer is yes. One of the problems with the neither confirm nor deny language. So instead he says, no, sir, not wittingly. Now, as we all know, that was not true. There are a variety of arguments as to exactly what was in Clapper's mind. Only Clapper knows the answer to that question. I talk about in the book the way in which, in a very unique way, this one person was whipsawed by competing obligations. Obviously, he has an obligation to tell the truth and the whole truth in sworn testimony. But he also has the direct obligation to keep the government secrets. Because the government had decided to keep this secret, that put him in the tough spot that he was in. Well, in just a couple of months, the first stories start to appear from Snowden's trove of documents, and we find out that the truth was not, no, sir, not wittingly. The truth was, yes, we scam. It turns out, yes, we do have programs of mass surveillance that affect millions and hundreds of millions of Americans. So just to summarize very briefly, what are the things that we learned from Snowden? Well, we learned of the existence of this domestic bulk collection program of telephone records, the orders to the telephone companies. We learned about internet surveillance, programs called upstream collection and Prism, also called downstream collection. And that's the program involving looking at foreign communications, but incidentally looks at Americans who are communicating with those foreign targets. That's the content program. But we learn a lot more. We learn about many other NSA programs that undermine the security of communications around the world. Now, in a way, this is not really a surprise. This is what the NSA's job is to break into communications. It's just that a lot of people didn't know how good they were at their job. So maybe President Obama has encouraged a lot of people to understand that their agencies actually have a lot of dedicated public servants that do their job really, really well, like breaking into communications. But we hadn't had a public debate about how this was affecting the privacy and security of the whole world's communications, and that's because of excessive secrecy. So what happened as a result? Well, we ended up with an intelligence community that reacted in a way that is unusual. The normal reaction is, we don't comment on leaks of classified information, we don't confirm programs, we don't talk about it. This didn't work. There was just too much political heat for Jim Clapper to be able to go out there and say, I'm not going to comment on whether I was lying to the Senate a couple of months ago. I'm not going to comment on all these massive stories that's got everybody up in arms. So they decided to do the opposite, which is to release thousands of pages of documents. A lot of people don't know this, but by March of 2014, the government had released double the documents about NSA surveillance that had been leaked by Edward Snowden on its own transparency website called IC on the Record. Now, these documents were mostly orders and rules about how this surveillance could be conducted, what the privacy oversight was, things that I'd worked on for years. Many of them were opinions of the Foreign Intelligence Surveillance Court, redacted in some places, but really tremendous amount of detail that we learned from those documents. And then going forward, issuing an annual intelligence transparency report with details that the government had for decades argued were classified, now made public on an annual basis. But it went beyond transparency. It also resulted in significant accountability that actually, I would argue, strengthened intelligence. Now, this is my great image, stole it from the Electronic Frontier Foundation, the EFF, all your data. I actually think that this may, in some ways, not do exactly what the EFF wants, because it kind of makes the NSA look pretty cool. Anyway, Congress in 2015 was looking at whether to renew the legal authority, the Patriot Act, that allows them to collect in bulk all this metadata. And essentially, they decided, no, we're going to reform the program. A major reason for that is that a privacy board reviewed in detail the government's claims about how this had helped with terrorist attacks, and found that in each of those instances, this massive program of bulk collection had actually provided no unique value to the government. Now, this is an area where I felt quite embarrassed. I had worked for years on oversight of this program to make sure that people were obeying the privacy rules around access to this bulk database. I had been told that there was important terrorist incidents in which this bulk database had been used, and that seemed, and I basically accepted that at face value. And after the Snowden revelations came out, I even defended them on national public radio and said, you know, they've helped to stop a certain number of terrorist attacks. When this board looked in more detail, they found that, in fact, the government had that data from other sources, so it wasn't as valuable as we had thought. That was an important reason Congress ended that program. Now, I say ended, but it's important to understand they ended the bulk collection part of the program. The NSA analysts still were given access to this metadata, but on a case-by-case basis. It turns out that that made the program more effective. It gave them access to more rather than less relevant data, because without the secrecy and the logistics of having to collect all the data, they could look at smaller providers. They could get data of a richer source of data when they weren't collecting all of it. So that's an important and valuable lesson about reform. I also talked a little bit about the secret court. The secret court really is a genuine federal court with judges that are approved by the Senate, lifetime tenure. They are not quite the rubber stamp that people think they are, but they get skewed by the existence of a one-sided argument process, which we saw very much after the Snowden revelations had distorted the law. In the Freedom Act, one of the important provisions in that law basically says when there's an important legal issue, the court should appoint another lawyer to argue the other side of that legal issue. Interesting idea, something I learned in law school, tends to strengthen the quality of judicial decisions. I think it's already done that. I think we need to go a lot further with reforming the Foreign Intelligence Surveillance Court. It was set up to review wiretap applications. basically to say, is there probable cause that you are spying for the Russians, that you are part of al-Qaeda? That's a fairly straightforward decision that judges make every day. Now it's overseeing vast programs of transnational surveillance, and to have just a federal judge and a tiny staff perform that function, to me, is not going to provide effective oversight. I argue that instead of just bringing in lawyers, we also need to bring in technologists to help the FISA court. There's been a number of incidents in which the FISA court has reviewed NSA programs where the NSA made major mistakes in how they implemented the programs, and for the most part, these were mistakes involving what I call failed lawyer-technologist communication. The lawyer says, we've been authorized to do this. The technologist hears something different. The technologist comes back later and says, this is how it works. The lawyer says, oh my God, I've been lying to the FISA court for 2 years because I didn't realize we were getting this data. So having technologists at the FISA court would help. But the most lasting challenge was really something that came as a result, I'd like to say it's because of our country's strong support for the human rights of everyone around the world, including the right to privacy, but that's really not the reason. After the Snowden revelations, people like me, former intelligence officials and current intelligence officials, went out there and said, you have nothing to worry about. We have strong protections for the privacy of Americans. A lot of companies in Silicon Valley said, please stop talking about that. This is hurting our business. We have customers and users around the world. We don't want them all migrating to other services. You have to do something to reassure the rest of the world that you care about their privacy too. This photo here is from a meeting that President Obama had with tech CEOs in December of 2013. You may recognize the man he's talking to. So Google, Facebook, Yahoo, others, they have a lot of political power in a way that voters in Germany and Brazil don't. And that caused the administration to say, we have to do something about this. So they issued something called Presidential Policy Directive 28. That flows trippingly off the tongue. I've been accused sometimes of being a wonk on surveillance issues. I won't quiz you after this talk about what is Presidential Policy Directive 28 or FISA Section 702, but this is important. This policy directive basically laid down a marker for the intelligence community saying that foreign privacy matters, that there have to be rules to protect the personal information that is collected by agencies like the NSA in these bulk collection programs. And this particular quote, to me, sums it up. That everyone has to be treated with dignity or respect regardless of their nationality or wherever they might reside, and all persons have legitimate privacy interests in the handling of their personal information. This was a revolutionary concept for the intelligence community. What do you mean all persons? What about, I thought it was just Americans. I thought it was just US persons. Now I have to worry about everybody else? So here's an area where I don't think we've done enough on surveillance reform, and actually in many of these areas we haven't done enough. And that has to do with what I call in the book technological magic. For years, the intelligence community had been studying how to use encryption and privacy-preserving technologies to extract information from massive data sets with real privacy guarantees for all the people's information that are in that data set. We learned after some of the Snowden revelations that, yeah, the NSA vacuums up huge quantities of information. Usually they have some purpose for doing this other than looking at everybody's information, and they use people like me, lawyers, to try to enforce policy constraints on the analysts. And that can be fragile. You know, people can violate those policy constraints. Math is a lot less fragile when it comes to those kind of guarantees. So this is a picture of Seni Kamara, my colleague at Brown University, who has pioneered many of these encrypted search techniques. We haven't implemented them. You know, we're studying them, we're continuing to study them. Here it is, 2017, 4 years after Snowden. So this is an area where we have a lot of work to do when it comes to surveillance reform. I want to close thinking about the danger of abuse of these mass surveillance capabilities. When Ed Snowden was asked in his first interview in this hotel in Hong Kong, well, why are you doing this? Why are you revealing all of these secret programs and putting yourself in such risk when you haven't really shown us examples of the kind of domestic political abuse of surveillance that we'd seen in the past? We didn't have examples from Edward Snowden of, Obama using surveillance authority to go after his political opponents in order to discover gossip. We didn't have those examples from the Bush administration either. And what he said to that was, well, we're not always going to have enlightened leaders, essentially. He's worried about building an architecture of oppression in which it's very fragile. Someday, he said, someone else will be elected and they'll flip the switch, and this apparatus could be turned against us. Well, in 2016, a lot of people in my old community in the national security world were very worried that that person had been found and had just been elected. During the campaign, we all know about Donald Trump's rhetoric during the campaign and after that seemed to denigrate important constitutional liberties and rights, respect for religious minorities, and just the kind of open promises of abuse of civil liberties we'd really never seen before from any president. Even presidents like Richard Nixon hadn't gone out there and bragged about the kinds of abuses that they wanted to engage in. And because of that, people may not even have noticed that he actually endorsed warrantless searches in his campaign. There's an interview in which Donald Trump is asked what he's going to do about the dangers of terrorism. He says, I want surveillance. I want surveillance of the Muslim community. And yes, warrantless surveillance might be necessary. Now, of course, also, the dangers of abuse are not just something Trump might engage in. There's something that Trump supporters have suddenly woken up and discovered in their fears of the deep state. A few months ago, Donald Trump himself discovered the dangers of surveillance abuse, tweeting out, "Terrible, I just found out that Obama had my wires tapped in Trump Tower." Now, this shows a shocking ignorance of the fact that no president under our laws can tap the wires of someone else without, I was about to say without their consent, without a permission from the FISA court. But it also shows perhaps an opportunity among political opportunity where people who may fear Trump and his potential for abusing our civil liberties could unite with those who support him and are worried about people in the intelligence community abusing their power to go after him and his supporters. I want to close by talking a little bit about what should we do going forward. Part of the reason I called the book Beyond Snowden was to say that we've had a debate about Snowden that is focused often on him and what should we do about him. I have said that because of the reforms that his disclosures caused, my view is that he should be pardoned, even though I do agree that they also cause significant damage to national security. But I think more importantly than that is to reform our surveillance apparatus. So I've offered a detailed and rich list of policy recommendations near the end. Boiling them down a bit, we need even more transparency about how our surveillance system works. We need laws that respect everyone's privacy, not just the privacy of Americans. And we need to do a lot more to use the magic of crypto and other technology that can help us obtain the data we want without obtaining the data that we don't want. Taken together, I would say that we need a serious overhaul of how we protect privacy and civil liberties in the age of mass surveillance. And this puts me sort of right smack in the middle on the very, very far edge of the national security community, which finds many of my recommendations unworkable, but sometimes on the other side of civil libertarians who tell me, Tim, we just need to junk all these programs. We're never going to make them safe for democracy. And my view on that is simply that the programs are, in some cases, very useful for national security. And one thing we learned from the debate is that the public, for the most part, wants the intelligence community to have these robust capabilities. They just want more oversight. And so that's what I've tried to do in the book, is tell us how we can do that. So thank you very much.
So in addition to data being used for political purposes, what other major concerns should we have as Americans for our data being in the hands of the NSA?
Well, I think abuse of our data is something we've seen does happen. It certainly happened in the past. And it could be used for a variety of bad reasons. It could be used by an unscrupulous politician to try to leak damaging information for political purposes. It could be used to intimidate a whistleblower. It could be used just for overbroad invasion of privacy. When a program is set up in order to safeguard national security, there can sometimes be mission creep, where it then is used for broader societal interests, law enforcement, and so forth. So I think that the real point is that we are still very early in the 21st century when it comes to grappling with how do we protect ourselves in this age of mass data and of mass surveillance. And my argument is that our laws have to reflect that. We can't just be content with a law that says, well, if you want to get the content of my telephone calls or the content of my email messages, you're going to need a secret court warrant. What about all my metadata? What about all that communications that you have of me talking with people outside the country? I worry about that too.
What can you share about research into blockchain or smart contract technologies to improve transparency and privacy and maintain a level of surveillance?
Well, both of those technologies are very promising, and they show different ways in which we might be able to use new and innovative technologies. For blockchain, I guess the area that I think of immediately is audit. I think about the possibility of having a way of auditing how people are using data. But one of the ironies of our failure to employ some of these technical approaches in our efforts to protect privacy and civil liberties from mass surveillance is that much of the research into these technologies, including blockchain, including encrypted search, was funded by the government itself, in some cases by the intelligence community. And yet we still haven't really come to grips with how do we deploy these technologies at the scale that an agency like the NSA would use, despite the fact that we've made real breakthroughs, as I discuss in the book, in using them. I would need to give it a little bit more thought, but I think that's exactly the conversation that we should be having, is getting people like the people here at Google together with people from the intelligence community and exchanging ideas about here's the tools and tactics and techniques that we have that are really interesting crypto techniques. What are your needs? What are you trying to extract from data? How are you trying to audit against misuse? Those kinds of things. We had some early meetings when I joined the ODNI more than a decade ago, and they funded some research programs, but we haven't done enough to transform that into reality of deploying these technologies.
Hi, thanks for the talk.
Sure.
Really interesting. This is a really difficult question to ask, and I'm trying. I want to balance it and word it correctly. Given that I've definitely I knew what it felt like on 9/11. I remember that so clearly. I lived in Israel for a while and had my own fair share of situations there that made me worry about terrorism and threats to me or my family's life and things like that. But a lot of analysis has been done surrounding the value of a human life in how the government values that. And people have done that with the Department of Transportation, for example. How much money is invested to making our highways safe so that we can protect the people who use them, et cetera. And people have done this a lot. It's not an exact science or anything like that, but given how big the security state is, really, in the United States, and given that you've kind of been there and you've seen what it can prevent, what it can't prevent, you've had your fair share of knowledge of that. What are your thoughts on that? I mean, do you think that this? Do you think how important do you think it is to focus on this? Are we overinvested? Are we underinvested? Given how much could happen if we never had these protections in place. Also, the fact that there are some costs associated with that. This surveillance can really ruin faith in technology that actually could protect people against financial crime and things like that, because now suddenly people don't trust giving their information away where it actually might protect them from things that are more likely to happen than terrorism.
Right.
So yeah, it's a complicated question, and I hope it makes sense.
No, I think it does, and the question really comes down to, have we overreacted to the risk of terrorism? I think most people would say that we have in certain ways overreacted. I think in 2017 it looks different than it did on the morning after 9/11. We had a lot of experience in counterterrorism. And I think what I would suggest is that we simply look a lot more clear-eyed at the question of effectiveness. Two examples. I talked to you about the bulk collection of telephone records and how that program, we spent a lot of time putting together the legal rules that should govern access to the database and ways to protect privacy. But this was a massive database of call records, which clearly posed a risk to privacy. And we had some anecdotal information, basically, about how it had been used to prevent terrorism. But when that was put to the test by the Privacy and Civil Liberties Oversight Board after the Snowden revelations, the conclusion was actually this was not necessary. This whole program that had been in existence for more than a decade did not provide unique value in preventing any terrorist incidents. Even though it had been used in some terrorism cases, they already had that data. Now you contrast that to the Prism and upstream collection programs, which Congress is debating right now this fall, and the Privacy Board basically came to the opposite conclusion and said, of course this program has privacy implications, but we've examined carefully the effectiveness of the program, at least in terms of the terrorist incidents the government says it has prevented. We've looked at each case, and yes, it has provided valuable and unique contribution to help head off those terrorist attacks. Now, you could, I suppose, do some actuarial calculation and say, well, if those attacks had happened and a certain number of people had died, this would be the damage, and then we have to somehow assign a value to the privacy that has been invaded by having the program. I don't think, I wouldn't go that far. I think it's already a step forward just to ask the basic question, did it work at all? We've seen that we can get a lot more privacy simply by asking that question. Even if we put infinite value on human life and we say, preventing a terrorist attack is worth these kinds of programs. If it's not actually doing that at all, then the question becomes a lot easier.
If one studies the terrorism literature, the purpose of terrorism is to terrorize and to cause the empire to overreact and thus internally destroy itself. That's in all the writings. So, and we play right into the hands of that. And so terrorism accomplishes what they want, unfortunately. So is there any recognition that they're playing into the hands of the terrorists by overreacting?
That's a great question. I would say this comes back a little bit to the Trump administration. Trump is the rhetoric that he used in the campaign gave a lot of people who were experienced in the national security world a lot of fear that we would have these kinds of massive overreactions, and that we would play into the hands of terrorist groups that were promoting a narrative of a clash of civilizations. And we've seen with the travel ban and other policies that President Trump has in fact done that. At the same time, you have a permanent national security establishment that has learned some lessons, I would argue, over the past decade and a half or more since 9/11. The policy changes that were made by the Obama administration to protect the privacy interests of foreigners in their personal information, that's Presidential Policy Directive 28, a lot of my former colleagues said, well, that's out the window. You know, Trump doesn't care about foreigners. He's America first. So day one, you know, we'll see that directive rescinded. It hasn't been. It hasn't been, and in fact, it's been reaffirmed by the new Director of National Intelligence on very pragmatic grounds, which is that we need the support of many other countries in our intelligence activities. I would also caution, even though we've been talking a lot about terrorism, the intelligence apparatus is not just about terrorism. It's about broad foreign policy interests of you know, a very powerful country, the United States. And that's another reason I think that the reaction to the Snowden revelations was different than we've seen to other spying programs that were more clearly focused on terrorism. It was pretty clear that, you know, if the NSA is spying on the Chancellor of Germany, it's not because they suspect that the Chancellor of Germany is a terrorist. There are foreign policy interests involved in surveillance programs. So that's an important conversation to have. My view is that the calculation is different when you're talking about broad intelligence purposes, and that there are some mass surveillance capabilities that we should not be using for those broader intelligence objectives. We should only be using them for security threats like terrorism. So that would be my recommendation to Congress when it comes to Prism and upstream, is do we really need to be using this program for broader foreign policy interests as opposed to for the terrorist purposes that Congress, you know, was thinking about when they passed that law.
I think one last question. How do we, as citizens, forward the cause of civil liberties?
It's a great question. Well, I know that some of the folks in this room may know that Senator Dianne Feinstein is an important leader on intelligence issues. She is also not, I would say, a reliable civil libertarian, to put it mildly. So pressure on Senator Feinstein from people in California will have an impact on the debate Congress is having right now on Prism and upstream. Also educating people on how the technology works. This is an important audience here at Google that can look at some of the programs I'm talking about and have an intelligent conversation about IP addresses and content of communications and how selectors are used, taking advantage of that transparency I talk about. There's just an enormous amount of information that used to be classified at the top secret level when I worked in government that has been declassified and released about how much of this surveillance works. But it's still impenetrable to a lot of people. One reason I wrote the book is to make it understandable to ordinary people. It's a reason that I use ordinary words like mass surveillance instead of jargon that the intelligence agencies like collection of signals intelligence under Executive Order 12333. And this has caused some of my former colleagues to say, hey, this is scary language, Tim. You know, you're scaring people. You know, you should tell them about all of our privacy protections. But my view is it's important to use plain and ordinary language about what the government is up to. If we agree with what they're doing and we think the protections are good enough, then so be it. But we shouldn't be having a conversation that's clouded in euphemisms like signals intelligence instead of mass surveillance. So you all here in the tech community can help illuminate these issues for the public. And organizations like EFF and ACLU are always looking for people who can help them out. In fact, the ACLU of Northern California has an open position. I don't necessarily want to recruit everybody here away from Google, but for a technologist. And whether you end up doing like what I did and working as an activist, or whether you just want to join with the group and help them out, I just think that the talent in this room could be so helpful to those kinds of groups as they advocate for privacy and civil liberties. And I would also encourage you to look into government service and to see what you can do to make a difference on the inside. I'm very proud of the service I did, as limited as some of my victories were. And having people who understand how the internet works and how technology works will help the lawyers and the officials ask the right questions, which they often haven't asked in the past.
Well, thank you, Tim. Let's give him one more round of applause.